Welcome to another episode of Behind the Wheel. I want y'all to listen to this law, the Supreme Court decision and affirmation that they completed, along with the good brother Dr. Ray. Please do not confuse this with any sovereign citizen thing. No, that's why I'm glad that they stated this in the Supreme Court. All right, this is shout out to my cousin Anthony.
Give you an idea of what I'm talking about. Okay, again, you file this. What I'm saying, you file this by sending it to the Attorney General of the United States, and by sending it to the Attorney General of the state in which you live. All right. Now, I'm going to share with you again mine, and then you can get an idea of what I'm talking about. All right. This is what I sent to the United States government and to the government of the state I was living in at the time. It says, then I state my name, Ray Hagins, or Ray, okay. Then it says family of Hagins, okay. And there's a reason why it's written that way, okay, for recognition, okay, for a certain level of respect that it's a part of their English law, okay, as far as explaining, for they
examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution addressed to either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department representing the United States.
Now, don't you think we need to know the answer to, at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office, and the D.C. Circuit is right that there is no immunity from prosecution, won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and as alleged in the indictment here.
President... Fact, my law. Okay, and from this point forward, okay, I have what is called automatic estoppel. Estoppel, spelled E-S-T-O-P-P-E-L, I think, means that it stops right here, right now. It can't go any further. All right, so when I'm presented with a situation, all right, such as a traffic stop, for example, all right, and law enforcement officer sees this document, that has to stop right there. Can't go any further. Yeah. Okay. Let's read on. It goes on to say here, now specifically in the United States.
Conduct that might have been charged as a federal crime, and you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of
safeguard. Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article II challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who
under the principle of entrapment by estoppel, this is a due process United States versus Lanier, that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years.
Certain rights, but those rights are meaningless to you if you don't know you have them. In fact, there's an old adage that says, he who does not know his rights is no better off than he who has no rights. Okay, understand this. You need to know how to walk and live in your power. But you just can't do it. You have to say something. You have to declare your power. All right? It's just not automatic. Because the way the system is designed, what is automatic is for you to be under their power. for you to be a ward of the state from the day you're born to the day you die. Okay? And it's called the doctrine of parens patriae. Don't take my word for what I'm saying, brothers and sisters. That's Latin. Parens, it's spelled, and write this down, please. Parens. That's the first word. Parens. Parens. The second word is patriae. Patraie. I believe I spelled it correctly. Patraie. Parens patriae. The doctrine of parens patriae, brothers and sisters. And again, the masses don't even know about this. Okay, so how can you speak against something you don't even know about? How can you resist or refuse something that you don't even know about that's happening? Okay, in your place or under to represent you, or you declare otherwise until you actually give them notification that you no longer agree, because they did this without your consent. In order for a contract to be legal and binding, the parties involved have to mutually agree to it. Understand this, man. Okay, you have been contracted without your knowledge. If you didn't agree to it, that contract is void. Yeah. So let's talk a little bit more about this document. Then what we'll do is schedule a workshop, and you guys can register for the workshop, and you will be able to complete your own documents. Okay, we'll break it all down to you, answer whatever questions you have at that time for the workshop of how to file this, how to go about it, And well, let's understand what's in it first of all. Okay, let's hear a little bit more about this document and what power you would have after filing it. You don't have it yet, but after filing it, okay? It goes on to say, and this is what's in mind, as a peaceful man, notice I said, as a peaceful man, right? I didn't say as an angry man, okay? I didn't say as a black man. It's not necessary to say that. What is necessary to say is as a peaceful man, because you're filing a very powerful document here, okay? As a peaceful man, or as a peaceful woman, if it's a female filing the document. As a peaceful man desiring to avoid conflict. Again, notice the wording here. Desiring to avoid conflict and live lawfully within maximum freedom. I have recently been studying the history of the United States along with its legal systems and have come to some very interesting conclusions. After reading various acts, ACTS, after reading various acts and exploring the way language is used in those acts, I have realized that lawful and legal are not always the same. It also appears that all acts and statutes in the United States are only contracts based in commerce. Therefore, I am now contacting the various government officials named above, meaning again the Attorney General of the United States and the Attorney General of the state in which you live, right? Contacting them named above in the hopes that, notice how I'm wording this, in the hopes that someone can either confirm or correct my understanding. Notice how I'm saying this, okay? I'm submitting this. If I am in error, I need it to be corrected. Correct me if I'm wrong, okay? That kind of thing. It goes on to say, if you choose to respond with corrections I must insist that you do so within 14 days of the service of this letter. You can say 14 days or 21 days, however many days you want to give them, but it has to be reasonable time according to law. According to Black's Law Dictionary, reasonable time for a response is any time after 14 days. Okay? If you say respond within 3 days, that's not reasonable time for turnaround. Okay? All right? So it says, again, I insist that you do so within 14 days of service of this letter in writing, by way of or via registered mail, and provide proof of your claim under oath or attestation with full commercial liability and penalty of perjury. In other words, if you try to tell me that what I stated here is not true and find out that it is true, then you're guilty of perjury, okay, and can be judged accordingly. Goes on to say, a lack of response. And by the way, I can tell you right now, they're not going to respond to this document. You're not going to get a response. And the truth of the matter is, you don't want a response. Okay? You don't want a response because first of all, you're not saying anything in your document, okay, that's wrong or illegal. You're just declaring your understanding. And your understanding becomes your law. Okay? Unless they can prove you otherwise. It goes on to say here, okay, a lack of response or response that does not contain proof of my mistaken understanding on a point-by-point basis will be assumed to imply agreement with my understanding. Failure to dispute the claims made herein will result in an automatic default judgment and a permanent and irrevocable estoppel by acquiescence. In essence, brothers and sisters, what that's saying is, okay, not just one general statement saying each point that I've mentioned. You have to, if you can't invalidate what I'm saying, then what I've said, it must be assumed that what I'm saying is in fact my law. Okay, and from this point forward, okay, I have what is called automatic estoppel. Estoppel, spelled E-S-T-O-P-P-E-L, I think, means that it stops right here, right now. It can't go any further. All right, so when